What are the IPLA challenges for NFTs built on blockchain? Imagine owning a digital artwork or a music clip with a simple click, but not knowing who actually holds the rights behind it. That's the core of the legal puzzles surrounding non-fungible tokens, or NFTs, on blockchain. These digital assets are unique and stored on a blockchain, making them different from regular cryptocurrencies. But this uniqueness brings a bunch of legal questions about intellectual property rights. When you buy an NFT, you might think you own the art or content outright, but that's often not the case. Usually, you are just buying the token that proves ownership of a digital item, not the copyright or other rights attached to it. This can cause confusion because many buyers assume they get full rights, but the original creator still holds copyright unless they explicitly transfer it. Another tricky part is the complex web of people involved in creating, minting, selling, and buying NFTs. There are artists, platforms, marketplaces, and collectors, each with different rights and responsibilities. This makes it hard to determine who is liable if someone infringes on copyright or trademarks. Blockchain's permanent nature means if someone uploads or copies content illegally, that record stays forever. This can make resolving disputes difficult because once an infringement is recorded, it's hard to change or remove. Smart contracts, which are digital agreements embedded in NFTs, can include licensing terms or royalty payments. But since these contracts are not standardized across platforms, enforcement can be inconsistent. This leads to questions about what rights are actually granted when someone owns an NFT. Trademark issues also pop up. Some NFTs use brand names or logos without permission, which can cause brand confusion or dilution. Because blockchain is decentralized, it's tough for trademark owners to monitor or prevent unauthorized use. Courts have ruled that using trademarks without permission in NFTs can be infringement, especially if the NFT references well-known brands. Enforcing these rights across different countries adds another layer of difficulty because of jurisdiction issues. Trademark owners need to register their marks in digital categories and keep an eye on NFT marketplaces to protect their brands. Patents are less common but still relevant. Some blockchain technologies or features used in NFTs might be patented, raising questions about licensing and enforcement in this decentralized space. Legal frameworks for digital rights management are still catching up. NFTs can help prove provenance and control access to digital works, but laws need to evolve to support these new tools. Clear licensing terms and transparency are essential to avoid consumer confusion about what ownership really means. Because blockchain ownership can be pseudonymous and spread across borders, tracking down infringers and enforcing rights becomes more complicated. Finally, the lack of standardized licensing models across platforms makes it harder to ensure consistent protection of intellectual property rights. As the NFT world grows, legal strategies must adapt, and clearer rules need to be established to navigate these challenges effectively.